using the same mailing address that we have for you on the court file?
Yes.
Thank you. You can be seated. Today is the date and time that we have scheduled the state's motion. This was a motion that was filed previously entitled Motion for Court Approval of Review Team Process. I did have an opportunity to review a response that was timely filed by the defense. And in addition, after the last court date, the people were able to provide Exhibit A, which had not been attached to the original motion, but the court found it quite necessary to include it. So we received that shortly after the last time we were together for court, and I've had a chance to review that as well. I know that because that was filed after the fact, the defense was provided an opportunity if they wanted to supplement their response. And it's my understanding that no additional response was provided. You intend to rely on your original response?
Yes, Your Honor.
Okay. Both of you can place any argument that you like on the record if there's anything else you would like to add or focus on that you had outlined in your original written motion and response.
Judge, I think I will just briefly.
Okay.
Thank you. Judge, what we have here is sort of an odd situation where I think we're all in agreement that the defendant has rights that need to be protected, and the people's position is that our review team policy does protect those rights. I know we're all on the same page, now, no pun intended with the document, but what we have here is a policy that gives the defendant adequate protections, but still allows this process to go forward. What we have is a policy where search terms are created by both the defense and the government. And unfortunately, the court does have to do some refereeing here. If search terms cannot be agreed upon, then the court, kind of has to step in. Our third-party vendor, which is called KL Discovery, which is not something that was included in the brief, they're the ones who do the search, and they're the ones who essentially control F these documents and find any of the search terms that were either agreed upon by the parties or ordered by the court. And ultimately, Judge, what we have here is a process where the defense is getting the first initial opportunity to determine if there's any potentially privileged information that should not be going to the government. And it's only after they make that determination that our review team has a chance to look at those materials, and if there is any disagreement, then ultimately our office, the review team, would file a motion with this court, and this court would be the one that decides the legal question of whether or not a document is privileged. What this isn't, Judge, and I think it's a weird way, but the way to look at how this policy protects the defendant's rights is to talk about what it doesn't do. And this is, I'm expounding on sort of something that was in our brief, is what this document doesn't do, as I said, is give the government the first opportunity to determine privilege. It's not a policy or a process where the government's review team can sort of unilaterally give materials to the investigative team without the defendant having an opportunity to object, or have a say-so. It's not a policy where the government can ignore the defendant's objections. And it's not a policy or a process where the government is performing this judicial function, which is outlined in, make sure I get my name right, in the In-Re search warrant case out of the Fourth Circuit. There the court was concerned that the government's review team was performing a judicial function, answering questions of law. In this case, Judge, in our policy, the government's not doing that, because ultimately, if there is any dispute regarding the question of law as to whether a document is privileged or not, this court would be answering that question, not the people. So the people's position is that this policy does adequately protect the defendant's rights, by any legal metric, by the case law that I think we're both citing. The only thing I would add also, Judge, is Mr. Gleason and I are kind of on the same page in that there's no statute, and there doesn't appear to be any case law, state or federal, that mandates that taint teams must be used. But what I will say, Judge, is that during the Flint water investigation, just like in this case, the government's team had luckily not as much as in this case, but a tremendous amount of electronic material. And when we had that material in our possession, the defendants claimed that some of the material may be privileged. And Judge Kelly of the Seventh Circuit Court ordered that a taint team be used, almost exactly to the one that the people are proposing. And an appeal was made with the Court of Appeals. the Court of Appeals denied leave, saying that there was nothing we need to look at with respect to Judge Kelly's order that a taint team be used. And that decision was appealed to the Michigan Supreme Court. And the Michigan Supreme Court, again, denied the application for leave. So I know there's no statute or case that directly says that taint teams must be used or how they should be used, but it's very clear that in that instance, Judge, in a case very similar to this as far as the materials we're talking about and the privilege concerns that have been raised, that at least one panel of the Court of Appeals and the Michigan Supreme Court has no problem with a circuit court, or in this case a district court, ordering that a taint team be used. So I think it's clear that in the state of Michigan this kind of process can go forward without trampling the defendant's rights. I'm sure I'll have a little bit in rebuttal for whatever Mr. Gleason says, Judge, but unless the court has any questions, I'm happy to have a seat.
No, that's great. Thank you.
Thank you.
Your Honor, I think we are in agreement that the attorney-client privilege is a cornerstone in the state's jurisprudence. It is something that you, before you took the bench, exercise with your clients. I do it every day with mine, and it is there for a reason, and it has been there from time immemorial in terms of what attorneys and how they communicate with their clients and how the clients communicate with the attorneys. The Troy Police Department was notified on February 5th that the items that they seized contained potentially privileged communications between Ms. Peterson and her attorneys, not just me or Mr. Cranmer, but other lawyers at other law firms. It appears that despite that, the Troy Police Department examined those laptops and Ms. Peterson's cell phone, because if the court looks at page 17 of the swear-to, Detective Trigger indicated to the magistrate that in fact further review of the cellular devices and laptops pursuant to the search warrant showed investigators' messages. So they've already looked at them. And this motion comes a little late in that regard because the police department already did it. And that's a problem. And Mr. Kessel also used that information to argue for bond that same day, indicating that information had been found and these are reasons to detain Ms. Peterson. The use of a taint team, I submit to you, is a usurpation of the judicial function. The lawyers don't get to determine in an adversarial case what is privileged and what is not. You do. Judges do. The executive branch does not get to review my communications to determine whether they're privileged or not. The proposed taint team are assistant attorney generals. Those are people hired by Dana Nessel, paid by Dana Nessel, sometimes promoted by Dana Nessel, but they're in her office. It's the same office. This isn't some independent group. It's the Attorney General's office. And that's not the judicial branch. And yes, I agree that creates perhaps more work for the court, but that's why we have courts, to make these calls as to what's privileged and not the prosecutor. If this were a civil case, would the plaintiff get to decide what communications are privileged for the defendant or vice versa? Absolutely not. There's no difference here because it's a criminal case, and I think even more so here because in a criminal case, one side has a tremendous amount of power, the government. The government has search warrants, administrative subpoenas, arrest powers, none of which a defendant has. And in these scenarios, far more than even than a civil case, the judiciary is the one that says to the executive branch, you've gone too far. We come to you with search warrants and say, Judge, you need to decide whether this violates the Fourth Amendment. We come to you to decide whether an interview has violated Miranda and the Fifth Amendment. We come to you to decide whether due process has been violated. We don't go to the taint team at the Attorney General's office to make that decision because you're the judge. And that's what the people of the state of Michigan and in this district are elected you to do. The Flint water case, I submit, is a misnomer because, as I recall, that case kind of fell apart for the Attorney General. And so it was never reviewed upon a conviction. It was interlocutory. And I have yet to have the Court of Appeals in any of my cases decide anything for a criminal defendant interlocutory. They wait till the conviction enters and then decide the case. So I think that's kind of, to say they declined to hear it mid-case isn't authoritative. The policy that I got, the court received afterwards, it doesn't exactly work like Mr. Kessel is representing, I don't think. It's not as if this vendor, KL, whatever, gives everything to us to review before the Attorney General's office sees it. That's not what happens. In subparagraph K, there's a privilege team that's assistant attorney generals that makes it determine whether it's privilege withhold, privilege redact, privilege exception, and not privileged. That's the Attorney General making that determination, not me. And then when you look further on, it's subparagraph O1 through O3. The Attorney General's office, the taint team, can turn over whatever it wants, whatever it decides is not privileged. The only stuff, as I read this, that we get to see is when the taint team says, oh, maybe this is privileged, or oh, this is privileged. The stuff that the taint team decides is not privileged goes immediately to the investigative team before I even see it. So not only do we have the executive taking your power away from you, which should not happen, we also have a policy here that's designed that all this takes place before we ever get to see anything. It's not as if they give us all of the material and say, this is what. They only give us a small slice. What they find is not privileged, they turn over. And we have no way to deal with that. But that's...
Wait a minute here.
Sure.
Can you please go to the top of page 8 of 9 under section O, which you just referenced?
Yes, Your Honor.
So section O is specifically outlining the handling of potentially privileged materials designated as not privileged. And you just argued, which is important, because in some of the case law that was reviewed, this was really a deciding factor when you have material that's reviewed and a team that has been developed and serves as the filter team or the taint team or whatever language you want to use, makes the decision in the other cases that certain materials are not privileged and they just turn them right over to the investigative team. That was problematic for one court. And I reviewed Exhibit A and noted under every section, including the section where the materials have been determined to be not privileged, there's still a component that requires that all of that material has to go over to the target or the target's counsel, and a reasonable opportunity must be provided to review and either agree with or object to the review team's designation. And if there's not an agreement, after that occurs, comes back to the court. So I see this as even the material that's determined to be not privileged still goes to you and to Ms. Peterson for review before anybody gets it.
I don't read it that way, Your Honor. If the court looks, the review, the categories that the taint team creates is subparagraph K. Privileged withhold, which is supposed to be, I think, returned to us. Privileged redact, privileged exception, and not privileged. In paragraph 03, the privileged team may turn over not privileged material to the investigative team. So under K1D, the privileged taint team, whatever you want to call it, filter team, if they find in their determination, not ours, they can turn it over under 03.
After 1 and 2.
No, because 1 only requires the potentially privileged material to be turned over.
Well, and I'm going to let you continue, and I'm sure it's not welcome that I'm interrupting what you have an opportunity to say at this point, but this is important to me, so I want to make sure that I understand this, but I also very politely want to point out that this is part of the reason that I had asked if you wanted to supplement your response after we actually got this document, because part of what I'm sure we'll get to here in a moment is that there is case law that specifically addresses the use of a filter team or a taint team, and a lot of the decisions that I saw have been made by the U.S. Court of Appeals really hung on language here, and so this is something that I think we want to all make sure we're on the same page.
Understood. I thought it was clear, because here's what I'm seeing in 01 is that the privileged review team sends it to me. So the privileged review team already has it, has already made its decisions among those 4 categories. And that's what the cases that I cited you was the problem. Because the defense attorney is second in line. Even if, and again, we're moving past my judicial function argument, but But the concept here is, and I think the cases that I cited, is the fox and the hen house and what we read there. Here, the privileged review team has the stuff first, and that's the distinction, and that's why as I read it pretty clear, because it's not KL the vendor sending it to us for us to do our review. KL sends it to the privileged review team at the AG's office, and that's the problem, and that's how I read that. And Mr. Kessel wants to say to me I'm wrong. That's fine, but it's the plain reading of the policy, and I think he has to. I think if you ask him, he has to answer yes. We send the electronic devices out to KL. We give them search terms. Then it comes back to our privileged taint team in our office, and from there it comes to us, and that's the problem with the policy. And I think that's the overall problem with all of these filter teams. Again, it's injecting the executive branch of government where the judiciary should be making that initial decision.
Okay.
And again, I don't think, in a civil case, if I were to get interrogatories or requests for documents, the attorney for the party, would do the review. I would create a privilege log. I would send it to the other side, and if they disagreed, they would come to you. They wouldn't say, I want to see those. I mean, that's the whole purpose of the court reviewing privilege. So that's why I'm thinking here that the policy doesn't work, and it really doesn't work just because of this idea that you make the decision.
Okay. So I don't think what you're saying then is that you, initially it appeared as though you were indicating that at some point in this policy, when some determination has been made about a subset of the material, there's an automatic right for the privilege team to just release it to the investigative team. I disagree with that. I think your bigger issue is that, your bigger issue really is there should just be no filter team. That's what you're saying.
Correct.
Okay.
If there's a vendor KL, those documents, it's pretty much emails, right? That's what we're talking about, communications, attorney-client privilege. Those emails should come to you. I can't imagine there's tens of thousands of them.
So
it's a small
where
business.
was the case law that supports your position?
The case law that supports my position, Your Honor, I cited in my brief.
Well, the case law that was cited, from the court's perspective, it was really 3 cases that
Yes.
both of you utilized and took different bits of information and different parts of the opinion to support your position. But if your overall position is the law does not support the use of a filter team, period, in a criminal case, where is it?
I
Where's that
believe
law?
that's the standard, the fact that the judiciary, because I don't think there is a Michigan case, Your Honor. I don't believe there is one. And we've cited federal cases. In the U.S. Attorney's Office, I will concede federal prosecutors continue to use taint teams. And I'm arguing under the Michigan Constitution as much as the federal.
Okay.
This is a judicial function.
I 100% agree with that. So that isn't something that you have to convince me of.
Right.
But ultimately, the process in which the court maintains its judicial function seems to be what is up for debate, I think, at this point.
Here's, if I may, Your Honor, what
Yes,
I
of course.
propose. The use of a vendor, the vendor's going to get used no matter what. Someone is going to go and figure out where the Varnum or Miller Canfield emails with Ms. Peterson are. The question is, in my mind, who gets to review those first? And I think if we're going to use a taint team or if we're going to use something, we get to review them first because it's her privilege. And this policy doesn't allow that. The only thing they give us are the potentially privileged materials.
I think the notion that's a little bit difficult for everybody to wrap their head around is the court's not being asked to pick between Mr. Kessel or Mr. Gleason to review the potentially privileged documents because I couldn't. I couldn't pick one of you over the other.
Right.
That would simply be unfair. I think what we're struggling with is the notion that the proposed filtered team is comprised of attorneys that work for the Attorney General's office. but I think it would be a little bit unfair to say that the proposed policy as it's been presented to us doesn't make, I think, it very clear that it's not to be anybody that is a part of the team that is working on this case. Yes, there are going to be employees or attorneys of the Attorney General's office that would be identified and would serve on the filter team if the court approves it. But I feel like, for argument's sake, there's an attempt to appeal to the general sense that the court would approve a filter team like this, and I'm essentially letting the Attorney General, Mr. Kessel, make the decision on privilege. But I think it's really a little bit more nuanced than that. I need to see a policy, a proposed policy or protocol that clearly identifies, to the extent that it can, that anyone that would be involved in this process after the vendor culls all of the discovery and gives whatever falls under gives the discovery that falls under the parameters with the search terms, and they review it, but they would be separate from your side or Mr. Kessel, really. So I think I really would like to hear Mr. Kessel probably focus a little bit more on that, just so we can have a record.
Understood.
And I understand your position very, very clearly. But I just think in general, I want to hear Mr. Kessel argue to the extent that he can what's in the proposed protocol that is identifying a separate and distinct body that would review the information that comes from the vendor and make it very clear to the court, if he wants me to consider what's proposed, that it will be not one single person that is involved in this case or is working on this case or has worked on this case or may work on this case, because I think that is the key component here. And I worry that when the argument really centers around, well, Judge, you're just going to give it to the AG's office to review everything and make the decision, I just want the record to be very clear that it wouldn't be just turning it over to Mr. Kessel to review everything. No. My expectation is it is a completely separate and distinct body of attorneys that would be doing that, and the defense hasn't proposed anything that I could consider from their end with a separate and distinct set of attorneys.
I proposed to Special Master or the court to just review those emails that are determined to have come from Farnham or Miller Canfield. My view is if we're going to if we're going to allow a privilege examination to occur, right, that doesn't involve the defense counsel or the prosecuting attorneys, it should be someone who is neutral, impartial, and uninvolved with the process. And my view of the world, and I have the utmost respect for Mr. Kessel, but the decision you're making here, because we don't have one in the state of Michigan really, isn't just going to apply in this case. This is something the court looks at in terms of every prosecutor's office, the Attorney General, county by county. And to me at least, the review of what's privileged or not, the first person who should decide whether to raise privilege, because there are certain instances like advice of counsel where you might not raise it, but that initial decision should be made by the holder of the privilege. I think that's what my argument is.
Okay.
Thank you.
Thank you.
Judge, I think maybe the better focus might be looking at section H sub 1 sub A, which is on page 4, where after the search terms are agreed upon, and again, that's something that Mr. Gleason and quite frankly the review team in my office is going to hash out. I'm not even a part of that. And again, if we cannot agree on search terms, then again, unfortunately, this court would have to kind of come in and play referee. But once this court orders those search terms are put in place, those are the terms that will be used to look through, like I said, sort of control F these documents. And what the policy says is that materials over which the target or target's counsel claims are potentially privileged material, that means anything that hit, right? So any document that contains any of the search terms that either we agree upon or this court orders. those are potentially privileged documents. Anything that hits as potentially privileged goes to counsel. And material over which the target or the target's counsel do not claim the privilege or are not potentially privileged may be turned over to the investigative team. So anything that does not include any of these search terms, yes, that goes to the investigative team, not because we decided it or not because counsel decided it. It's because those documents simply did not include any of the terms that ultimately this court may have to decide may include some privileged material. Once there are potentially privileged materials, i.e. anything that hits on any of the search terms, counsel gets that, okay? And at that point, Judge, this court makes rulings of law on argument all the time. The government will come in, whether it's the city attorney, the Oakland County prosecutor's office, my office, we come in and we say, hey, Judge, this search was legal and here's our position, or this questioning was legal and here's our position. And defense counsel, whoever it is, comes in and they take a position. And ultimately, this court decides the question of law as to whether or not a search was valid, a statement was good, rights were violated or not. And that's all that's happening in this case, is the review team in my office and counsel review this set of potentially privileged materials. And in most cases, I imagine, there probably will be a lot of agreement on things. Where there's disagreement, my office's review team takes a position, defense team takes a position, and nothing happens until this court orders it. So I think that's the step that this court recognizes, and I think Mr. Gleason is kind of skipping over, is nothing that is potentially privileged goes to me without either a stipulation with Mr. Gleason and my review team or this court's order. Nothing goes to us that they claim is privileged until you order it, Judge. And then, as you correctly pointed out, that's the difference between our policy and the policies that were in these cases, right? In the Fourth Circuit case, the government review team said, okay, well, we'll look at everything and we'll decide if privilege applies. And before the defense has a chance to raise an objection or claim a privilege, we're just going to give it over to our investigative team. And the Fourth Circuit rightly said, no, you can't do that. You're not the arbiter of privilege, right? Because in that instance, the prosecutor's office is performing a judicial function. The prosecutor is not just taking a position on the law, but is really making a ruling on the law as to whether or not privilege applies, and then immediately giving the documents to the investigative team. Obviously, that's not what's happening here. So the fact that my office will argue that something might not be privileged doesn't mean we're performing a judicial function any more than it does a prosecutor's office taking a position on any other question of law. We would have an argument, Mr. Gleason would have an argument, and this court would be performing that judicial function, answering the question of law. Judge, as it relates to that other case, In re Grand Jury Subpoena, the Sixth Circuit case, again, we have a government policy that is very different from the one that we are proposing, in the sense that in those cases, in that case, the government was proposing, we will do the initial review, we will decide what's privileged, and we will be sending our things to the investigative team. Again, Judge, that is not what's happening here. And in fact, the defense in that instance proposed a policy very similar to what we're proposing, which was that a separate party perform a search, the search terms that are agreed upon or court ordered, anything that hit would be given to defense counsel looks at things, defense counsel lets the prosecution know what their position is, prosecution takes a position, and any conflict would be decided by the court, which is exactly what the people are proposing here. And Judge, what I would say is I would add, and I think the problem is, Judge, I think you kind of note it, Mr. Gleason's position seems to be that, taint teams are unfair and unreasonable as a blanket rule. And Judge A, we know that's not true by the case law, right? But also conflict walls exist all over the place, Judge. I'm sure there are plenty of conflict walls in Mr. Gleason's firm. Lord knows there are a million in my office as well. We get emails about them all the time. Conflict walls are a regular part of doing business in the legal world. That's just how it is. And Judge, to that point, what the Sixth Circuit said regarding the taint team, and I'm quoting here, government taint teams seem to be used primarily in limited exigent circumstances in which government officials have already obtained the physical control of potentially privileged documents through the exercise of a search warrant, which is, of course, what happened here. Continuing in my quote, in such cases, the potentially privileged documents are already in the government's possession, and so the use of the taint team to sift the wheat from the chaff constitutes an action respectful of rather than injurious to the protection of privilege. So there we have, Judge, the Sixth Circuit saying that in instances where the government is already in possession of electronic material, just like in this case, the process of a taint team is not only completely legitimate, but also recognizes and protects the defendant's attorney-client privilege, which again, I think we all agree is of paramount importance, Judge. When the court talked about the government's proposal, which was sort of like what Mr. Gleason's saying was problematic, the court said that the problem is that appellant's attorneys would only have an opportunity to assert privilege only over those documents the taint team has identified as being potentially privileged. But Judge, again, that's not what's happening here. The search terms that are either agreed upon or are court ordered, that's going to be the determining factor as to what documents are potentially privileged or not. It's not someone in my office or someone in Mr. Gleason's office. It's these terms that determine privilege. And then once something is potentially privileged, anything that hits is the universe of potentially privileged stuff, that's when, if there are disagreements, this court has to step in. Your court's absolutely right. I have nothing to do with it. I haven't seen any of these materials. I get what comes to me after either our review team and Mr. Gleason agree or after this court orders anything. So I hope I've kind of answered the court's questions, and I know there seems like some confusion about how this process works. So unless the court, happy to.
I'm familiar. I just want the record to reflect.
Absolutely, Judge.
Right, but I think it's appropriate for any case, but also in a case where there's a lot of attention that's being paid. I don't want there to be lack of explanation on the determination that is being requested as to who will review these potentially privileged documents. It's not just as black and white as the defense or the prosecution, and so that's what I was just asking you to speak to. But I think I understand the process, and I've spent quite a bit of time reviewing the case law that I think applies here. So thank you for placing that on the record. Was there anything else? I did see Mr. Gleason looking like he wanted to respond. I'm not sure how appropriate that is, but I will give you an opportunity just to weigh in on anything that was added to the record from the last argument.
Yes, Your Honor. And the cases that we cite about the filter team from the federal jurisdictions, they use the grand jury process, and so those are filter teams that are pre-charge looking at documents, where you may get documents from a witness or whomever, and maybe there's no adversarial system in effect there. Here, the case is already rolling, so we have an adversarial system. And if Mr. Kessel is correct that I get the documents first, why do we need a taint team at all? Because I can say, Mr. Kessel, I believe documents A, B, C, D are privileged. Let's take them to the judge and she can decide. Why do they get to look at them at all? I don't understand why they get a chance to see that when it's you who decide when we say it's privileged. I mean, I go back to my civil law analysis because adversarial cases are adversarial cases. Mm-hmm. And if there was a plaintiff here and a defendant here, and the defendant said, I have privileged documents, you're not going to say to the plaintiff, okay, wall off part of your law firm, take a look at them. You're going to say, show me the documents and I'll make the call. That's all we're asking you to do here is if in fact I am going to get those documents, I can say they're privileged, I can send them to you, you can look at them, you can either agree or disagree. But they don't get to take a peek. They don't get to do that in the civil context, and they shouldn't get to do that here. Because I'm hearing Mr. Kessel say, I get them first, but why do they get them at all.
Well, that would be the first that I'm hearing about anything related to how they obtained these documents. And this was something else that I really paid close attention to in reviewing the case law. There is a distinction in the way the courts are ruling, and they specifically look at who has the documents. The people have the documents already, and it's my understanding that they've obtained the documents as a result of a properly executed search warrant. So that's not, you can't debate that right now because that's not part of this motion. If that was part of the motion or the argument that was going to be made, this would be a whole different conversation. But
Right.
when I get the motion that I've received and the response that I have received, there's no indication that we are arguing the validity of the search warrant at this point.
I agree, that's a different issue.
Okay, so I don't want to go there. Obviously, it sounds like you don't either, which is good. But I do think there's a distinction in the way the law is applied in these cases because the government has these documents. I'm not making a determination right now that Ms. Peterson has all the documents and I'm forcing her to turn them over to the Attorney General's office. They have them, and they obtained them through what appears to be a properly executed search warrant.
An unchallenged at this point in time search warrant, I guess, would be the best way to phrase it.
And I know that you mentioned early on in your argument something to the extent of, once we get to is it privileged, is it not privileged, then we get to who reviewed it, who looked at it, how it was considered. That's July's agenda, actually, from what I understand.
Yes.
So I just want to get through June so that we can get to July, quite frankly.
All right. And I think at some point I'm probably making a record. However, I think when the court rules, and I'm getting the sense perhaps the court might be ruling against me, but that's okay. I think the court has to issue an order that tells us what to do, rather than because we seem to have different opinions about that policy. Mm-hmm. So I think the court might have to put in its order, this is how it's going to roll, I think is what the court should do, not just
grant the motion.
Grant the motion, correct.
Well, so I thought about that again. Why I was hopeful that once we actually had this detailed, lengthy policy or proposed protocol to look at, that there would have been an ability to have some thoughts on if the court determined that it would be appropriate for a filter team to be utilized, is the language that's in this policy something that the parties agree, or there should be an alternative? I can do that. I mean, I can clearly go through and indicate if there's any language in here that I feel should be different to comport with what I think the case law states, or in this situation, if you believe that there's something that you're not in agreement on in terms of how the terms of the proposed protocol read or would be executed.
May I suggest this, Your Honor?
I'm happy to weigh in on it. It
sounds like the court is going to allow the Attorney General to use the taint team. I don't want to say I'm prejudging the court, but I'm getting the sense I've appeared in front of you for a long time. Perhaps Mr. Kessel and I can propose an order to the court as we would in under a 7-day or something like that. And if there's any portion of the order that either one of us disagree with, we can file our objection. But that way we can write the order, and as I think the court encouraged us to do, without waiving my objection, it can be noted, and we can try and fashion the order. I try to make less work for the court, recognizing where I think the court is going.
I think it's still appropriate for me to make a decision on the motion in general.
Right.
I reviewed the proposed policy, and to the extent that any of the language included in the proposed policy or protocol, I should call it, is confusing, or there's some disagreement on how it would actually be implemented, I didn't really have an opportunity to weigh in on it. It appeared that the parties were taking very opposing viewpoints, that the people believed that the filter team is an appropriate way to address the issue of potentially privileged materials that were seized pursuant to the search warrant, and the defense was taking the position that under no circumstances was this something that the court could approve. So I didn't get into the details of the proposed protocol. I think in terms of issuing an opinion on whether or not a protocol can be established to address the potentially privileged material, I'm in a position to rule on that today. I guess what you're asking is if I'm telling you that this is a protocol that the court is going to require to address the potentially privileged material, do you want an opportunity to weigh in on what that should say? I'm not sure what you're asking.
I guess, Your Honor, what I'm hearing is that the court is not going to order the relief I request, is in that the documents come to the court and the court exercise its authority to determine whether they're privileged or not. In that case, what I'm hearing Mr. Kessel say to the court is that I get the results of the searches by this vendor first, before the privilege team or taint team gets to look at anything, and I get to make or Ms. Peterson gets to make the determination as to what we believe is privileged or not. That's what I'm hearing Mr. Kessel say, and that's, I guess, where I'm trying to find out what happens next.
Okay. Is that what you said, Mr. Kessel?
And Judge, what I'll say is part of the policy is also that there will be timelines that will be agreed upon. So, for example, if Mr. Gleason, we've got the potentially privileged documents, right? And then, okay, we have X number of days to go over these documents, and there is in the policy it says it's agreed upon that you can do X number of pages like per hour review, right? Because what we don't want is a practice where, okay, well, we have this review team, but it's going to take a year for everybody to go over everything, because that's not practical and that's not in the interest of justice and all that good stuff. So what we have are timelines that are set in the policy where we say, okay, this amount of work is going to be done at this point, so the process keeps moving. So if that kind of answers the question. But yeah, Judge, yeah, Judge, I mean, I think that's the people's position. I don't know if I'm really in a position to negotiate a department policy as far as particular issues that Mr. Gleason may have. I think ultimately the question is, does this court believe that this policy adequately protects the defendant's rights? And if it does, then we ask the court would adopt it.
I guess I'm struggling with your interpretation as well, Mr. Gleason, only because it appears as though what is being requested would, I'm not sure, it sort of negates the whole point of having the filter team. My understanding of the way that this proposed protocol would work, both sides, meaning Mr. Kessel, Mr. Gleason, his client, the other attorneys that are working with Ms. Peterson, they have an opportunity with some sort of time limit, because I'm going to go out right now and tell you this is something that I should have seen in March, quite frankly. And I'm a little bit frustrated about that, but I'm happy we're having an opportunity to fully explore this issue so that I can make a decision and nobody comes back at a later date and said that there's now a fatal flaw to the case because we didn't go over it. But that being said, my understanding of the proposed protocol is the two sides together are going to work to develop a comprehensive list of search terms that they believe, if utilized, will have the potential of catching any potentially privileged communication that your client had with attorneys leading up to the seizure of these devices.
Right.
And both sides get to weigh in, and I don't care how many search terms are on there, quite frankly, as long as both sides have an equal opportunity to weigh in and provide what they believe would be appropriate. If the two of you can't agree, or the two sides cannot agree on whether or not a particular search term should be included, you come back to me. I have the responsibility of making a decision, which I think is a responsibility that I will maintain on this issue until the case is over here, quite frankly. So I don't see any part of this as a decision that I would make today that would relinquish my duties to somebody else. So come back. We will argue about the search terms. I'll make a final decision. Once we are confident that we have a complete list of search terms that will identify any potentially privileged communication that may have taken place between your client and her attorneys leading up to the seizure of the devices, it goes off to a third-party vendor. clearly not somebody that's involved in either person's office in any way, shape, or form. I'm assuming the work that they do will be somewhat monotonous. It's going to be data, it's pulling data based on these search terms, not even something that you're going to have a number of individuals like laboring over to determine. Once that information is produced, however, my understanding of the protocol is that it goes to the filter team, not to the defendant, because if it went to the defendant to identify what's potentially privileged or to put it in all these categories, then I'm not really sure what the point of the filter team would be, and I'm still planning on issuing my actual opinion on that, but it goes to the filter team, and then the filter team has to work through each of the categories to make a determination, but at each point in the proposed protocol, whatever category it is identifying a potential document to fall within, there is a process that once the review team or the filter team or the taint team makes the determination, it goes over to you to look at it, review it, say yes, this falls in this category, no, this doesn't fall in this category, we don't agree with you, we're going to take this one to the judge, and the judge is going to review it and make the final decision. So that's my understanding of how everyone would be involved in this process. I understand that the preference, of course, would be for Ms. Peterson, that once the third-party vendor gets all of these documents, gathers them pursuant to the search terms that you've put together, everything just goes over to Ms. Peterson for review, but I don't think that's what the review team or the taint team is put in place for. So I didn't expect that that would be the outcome, and I don't think Mr. Kessel is saying that's what the policy would require, but I still find the safeguards that are necessary throughout the policy in that both parties are coming up with the search terms, and there's no limit to what you can put in there, quite frankly, and if you don't agree, I'll make a decision. A third-party vendor then identifies anything that could fall within that potentially privileged category, any of these categories, and once that information is provided to the separate and distinct filter team that is separate from the Attorney General's office, that is actually any attorneys that are working on this case, and they determine what category it falls within, at that point Ms. Peterson has the ability to review, object, come to court. So I think that's what the case law is indicating, is the understanding of the filter team. I'm not sure, but
I think the court, in denying my motion just now, I think has identified what the process is that the court intends us to do, and I understand that. So,
and I think it is supported. I'll just, and if you want to go back and sit by your client, you can, but I think it is supported by the case law, quite frankly. I think, especially as it relates to the in-ray search, sealed search warrant case from 2021, which I think is the most recent case out of all the ones that were cited here. It's very difficult for the court to find that this case doesn't apply here. Of course, factually there are some differences, but as we indicated, I think we all agreed on, like in that case, in this case, the government is already in possession of the documents that they were seized pursuant to a search warrant. I didn't get any indication, anything that's been filed at the court thus far, that there's an issue with the search warrant per se. So nobody's asking me to invalidate the search warrant. This definitely wouldn't be the appropriate way to do that through this motion. It appears that both sides are truly concerned about Ms. Peterson's privacy right and her right to maintain certain types of communication with her attorney as privileged. It seems as though the attorneys are before the court because they are genuinely wanting the correct outcome for a procedure here that will protect her rights. I also, of course, took a look at the fact that this is in the process of a criminal investigation. Charges have been filed. That's actually something that has to be considered and is a little bit different, but nonetheless, I think it meets the standard that's outlined in that case for the court to consider the issue. I will note that in this particular set of circumstances, which I found to be different than the other cases, it's not the defense raising the issue. It's the people So I know that this is an issue that has been negotiated, and it appears that the parties were trying to resolve this without the court. But in most of the case law, it's the defense, the defendant, the intervener that's raising the issue to ensure that their privacy rights are protected. Here we had the state file the motion, making sure that before anything occurred in this case, that the court had an opportunity to weigh in and make a determination about the appropriate protocol to follow here. So that was a little bit different as well, but nonetheless, I really do think that this case is one that the court cannot ignore. I've taken into consideration the defense position that generally they're objecting to the use of the filter team, that they believe that it would be more appropriate for the defense to review the communication and make initial determinations about privileged materials, and then give the state an opportunity to review, and they can determine where to go from there. I also took into consideration the fact that the defense was offering in the alternative that the court consider the appointment of a special master. Of course, I'm familiar with the term. I'm familiar with the federal law that actually outlines the circumstances in which that person would be utilized. There was no case law that was provided to the court that would support the court's decision to appoint a special master over what the people are seeking as the implementation of this filter team through the protocol they've submitted. Most of the cases where I could find that the special master was appointed, very different than this criminal case, quite frankly. And I didn't really find anything that would require the court to consider that. And there was little detail that was provided beyond just asking the court to appoint a special master to address this particular issue that's before the court. There really was overall a blanket assertion that no person that has any relationship to the Attorney General's office should be able to serve on a filter team, and the court finds that this assertion in and of itself really flies in the face of the court's opinion in the In Re sealed search warrant case from 2021. I think, let's see here. Despite the generalized position that the defense is taking that the filter team protocols that have been reviewed unfavorably by previous Court of Appeals decisions, when you take a very in-depth look at those decisions, it seemed clear to this court that while there is case law that criticizes filter team protocols, in those opinions, I think the courts did an excellent job of really defining what specifically they were taking issue with in those situations where the protocols were utilized. And in doing so, there is, I guess, a body of case law that's been developed that helps this court make a determination of what is appropriate, what isn't appropriate, and why that would be the case. So I think taking a look at the three cases that have been cited by the parties here, we have the 2006 case, which I know was referenced in oral argument as well, in Re grand jury subpoenas. There's some factual differences here, but of course, in this case, it was the government that argued they should be able to send a team in to review all of the documents. They did indicate that those would be government attorneys that were not involved in the case. However, the fatal flaw in that case to the government's proposed protocol was language that directed the taint team to immediately turn over information that they had determined was not privileged over, and it would go directly to the investigative team. The court really took issue with the privileged holder not having the right to object, and that there was, let's see here, not a clear opportunity, for the court to be involved in any final decisions on the issue where the parties did not agree. A clear addition to the language that allowed for this was sufficient to address the court's concerns in that case. The taint team procedure, however, even back in 2006, was otherwise supported throughout the opinion. Also citing the In Re search warrant issued June 13th of 2019, a U.S. Court of Appeals decision out of the Fourth Circuit, which has come up a couple of times this morning. Again, while taking a negative view of the filter team protocol that was at issue in that case, The facts are clearly distinguishable from the case at hand. In that case, the protocol was actually established by a magistrate judge at the time the search warrant was issued. The timing was deemed flawed by the court, as the ex parte manner in which the protocol was established did not allow the privilege holder to raise issues as they should have or would have if it had come before the judge in adversarial proceedings. The case that the court really is focused on in supporting the decision that it's making today is the 2021 opinion in re sealed search warrant that the U.S. Supreme Court determined that the filter team protocol that was at issue in that case did not suffer from any of the same fatal flaws that had been identified in the previous cases. In this case, the protocol was developed during the course of adversarial proceedings, as it is now. Both parties were given an opportunity to weigh in. In this case specifically, we've heard that a third-party vendor, which was named and identified today, would be responsible for gathering potentially privileged documents based on input from both parties to develop a complete set of search terms. In the 2021 case, the court maintained its judicial function in making final determinations on privilege. The protocol also appropriately created a system of checks and balances so that nothing would be sent to the investigative team before approved by the defendant or the court. As I've reviewed the proposed protocol in this case, which is listed under Exhibit A, it appeared that the Attorney General's Office has taken notice of the decisions of the U.S. Court of Appeals in determining what the protocol should be. Each step in the process provides adequate safeguards to protect Ms. Peterson's privacy rights. Furthermore, it makes very clear that the court would be the final arbiter and maintain its judicial functions on any and all issues that cannot be resolved by the parties, which would immediately be brought to the court to make a decision based on the law. So for should be granted. To the extent that you want to provide a written order, you can do that if that's the preference. I think other than that, you would get an order indicating that I've made my decision for the reasons stated on the record, so we could get it quickly. But I'm happy to entertain an opportunity for you to submit something under the 7-day rule if you'd like to craft language that you think may better guide you through the process. Oh, and to the extent I might have just said Supreme Court case, it was the U.S. Court of Appeals decision 2021. All of them were. And I hope I identified the appropriate district, but I want to make sure that the record's clear.
Judge, I guess I don't think we need to submit any additional orders if the court is saying that the policy can be adopted. I think we're okay. What I will indicate is, even though the court hadn't ruled yet, and I have spoken with Mr. Gleason about this, in E sub 3, there's a requirement that anybody who discovered, and that's on page 3, Judge, the individual or team that discovered the potentially privileged material must create a detailed record documenting how or where it was found and any actions taken thereafter. I have been in touch with Detective Trigger. I do have a list of Troy PD who came into contact with any potentially privileged information. I'm going to get that list of people. I can get it to Mr. Gleason probably before we leave the building. Those reports are being created, so those will be gotten to him as well, because I know that's going to be part of the motion that we're going to be hearing in July. So just to let the court know that's going on as well.
Okay.
And I won't belabor it. With respect to the court's first question, when I stopped talking, I think the court very clearly laid out what it expects, so I don't think we need an order. I think that's a testament to your abilities as a judge. In response to Mr. Kessel, I've previously off the record indicated that, and this morning, that the Troy Police Department looked at these devices electronically without a taint team. It's my understanding, and I can be corrected, that when they were looked at, no reports were prepared, which I find unusual, and those reports are now being prepared at the direction of the Attorney General.
Okay, so that's information that you just would like to make part of the record.
Yes, Your Honor, thank you.
Okay, so I will still generate a written order just indicating that the motion was granted for the reasons stated on the record. But can we just touch base about our next plan to get together, which is in July? We did pick a tentative motion date, but obviously the actual written motion has not been filed.
The court has informally, through Ms. Eversole's direction of the process, that I'm to file the motion no later than June 20th,
Yes.
and that will be timely filed by the 20th.
Okay. And then once I receive it, I don't know if we had given you a response time. Clearly, I'm just trying to get it close enough to the date that we are expected to have a motion evidentiary hearing, but I would like time to review it myself. So once we receive that, we'll give you an actual deadline, Mr. Kessel.
Sure.
And then we're still good potentially to be proceeding with that date that we've selected, which was Monday,
July 13th, Judge.
14th.
14th, sorry.
the 14th?
Yes, Your Honor.
Okay. I think that's it for today. Ms. Peterson, my recent information from pretrial services tells me that you're fully compliant with all bond conditions, so my intention was to continue the bond at this time. Is there anything else we need to address?
Not today, Your Honor, no.
No, thank you, Judge.
All right, thank you.
Thank you.
May we approach Your Honor briefly?
Of course you can. Just let me go off the record.
Thank you.
Would you rather just have a conversation in chambers so
That would-
they can pack up?
That would be great.
All right. Thank you. Make sure they
All rise.